allow students who are not present to review it afterwards. Okay, so yeah, okay. Please confirm again that you can see my screen.
Yes, we do.
Okay, great. Okay, so what we're gonna do, I'm gonna start with, yeah, I told you already that we're gonna examine previous exam questions. We're gonna discuss any questions you may have, so anytime you can interrupt me if you want. And we're gonna go through the legal concepts that we covered in class. So one quick disclaimer is that what I'm going to tell you today is everything that we have covered in class, but does not substitute what Professor Schultz said in class. So the advice is that you should focus on what Professor Schultz said in class and on what we had discussed in class and what is in the PowerPoint slides. We're not going to ask you questions that come from the mandatory readings in the sense that we're not going to ask you what happened in one case that it's mentioned in the mandatory readings. You don't need to know that. What you need to know and remember is the basic stuff, the legal concepts that we have discussed. And we'll go through that in a moment. It's important to remember not cases, not the mandatory readings by heart, but to focus on what Professor Schultz said in class and what issues we have covered there, okay? Yeah, I said that. Okay, so let me start with explain what the BOD exam is and what is gonna happen to you in a few weeks. So the BOD exam is a bring your own device exam, which means that you can use your own tablets, only iPads, and your computers. If you don't have a computer which is compatible with the requirements that the university has set, and which can be found in the very first session, in the slides of the very first session, then you need to raise that. You need to inform me and inform the BO team. I believe there is a formal procedure that you should follow, and you should be already aware of that because I'm told from the BO team that they have already emailed all students. So check your emails if you haven't done so, and if you face any issues, let me know. You don't need to worry too much about that because on the day of the exam, we will be providing computers to students who won't have any, and to students who face any technical issue during the exam, any unexpected issue during the exam. However, we don't have unlimited number of computers. That's why the BO team requests students to inform them so they know beforehand how many computers they will need to provide us with. So what you're gonna need to do when it comes to the exam, you will need to tell us, we will be giving you statements. A statement can be true or false, and we will like you to tell us whether it's true or false. If it's and then you will be required to explain why this is true or false. In total, there will be 30 questions. You will need to answer all these questions, and tell us whether it's true or false. The statement we're giving you, whether it's true or false. However, you don't need to substantiate every question. You only need to substantiate 10 questions. And we will indicate which questions we want you to substantiate. And we will be telling you how many points you can get from the question, from the substantiation, and how many arguments we need you to give us. In addition to that, at the very end of the exam, and I'll show you how it will appear, you will have the opportunity to substantiate 2 more questions of your own choice. So except for the 10 that we're gonna give you and ask you to substantiate, you will have the opportunity to give 2 more substantiations for 2 more questions. That's very beneficial to you because you will be taking 1 point for this substantiation, so in total 2 extra points. And by doing that, you will be able to remedy any mistake that you have made in the true-false question. So if I were you, I would use this option to substantiate questions that I'm not sure about whether it's true or false, and explain how I perceive the questions, how I understand them, and how and why I believe the statement is true or false. So 30 questions in total, true, false questions. And out of these 30 questions, you will need to substantiate 10 plus 2 more that you will be choosing from them. How do we evaluate this? We will be giving you 2 points for each correct answer. So if the statement is true and you say it's true, we will be awarded 2 points. And then we will be giving you 1 point for each correct and relevant substantiation. So we don't have negative points. So if you make any mistake, there's no negative point. We just not take the points of the question. So if the question is, awarded 1 point, 2 points, and you answer it in the wrong way, then you won't be taking any points. But there's no negative pointing system. Then when you are required to substantiate your answer, to explain why it's true or false, you will be we will be telling you how many arguments we want you to make. We will have a parenthesis saying 2 elements or 1 element that indicates the arguments that we want you to make. So if you see a question and at the end there is this parenthesis saying 1 or 2 elements, that means that you're gonna need to give us 2 arguments to explain why the answer is true or why the answer is false according to your views. And this also indicates that the maximum point that you can take will be 2 points. So that's how we evaluate the questions and your answers. Any questions so far? Is everything clear? You can interrupt me anytime. There is no need for you to wait. Any questions so far? No? Okay, cool. So as you all know by now, it's gonna be an open book exam. That means that you can bring your own notes. Sorry, let me admit one more student. You are not allowed to use tablets or phones. You will be able to use your iPads, only iPads, for some technical reason I don't understand, and computers, okay? On the exam platform, you will be given access to the slides, the reader, and the necessary legal instruments. You will be able to navigate through them freely, and you will be able to view them. However, these materials will be given as I have uploaded them on the Moodle, so they cannot be annotated. So if you want to use your own notes, if you have downloaded the slides and you have highlighted them, then unfortunately, at least for this year, you will have to print them in order to have them with you.
I'm so sorry to interrupt you.
Yes.
I have a question regarding just what you mentioned before. So I guess it's the same as regarding the reader. So for instance, in the PDF version, I highlighted certain important sections.
Yes.
Means that I cannot use it unless I order a printed version.
Yes. Yes. Unfortunately, at the beginning of the year, the bio team informed us that they will be able to find a solution and allow students to upload their own material somehow. Again, I don't really understand the technical aspects, but in our last meeting, they told me that this will probably happen start from next year. So unfortunately, you will have to print them out. My advice is that between me and you will not really need the reader for the exam, unless you have I don't know, highlight something relating directly to what professor said in class. But it's not that you're gonna have the time to go through the reader and find there the answer to the questions that we'll be giving you. Our questions will be based on what we discussed in class, mostly what's in the PowerPoint slides, and they will require you to show that you know the basic aspects and the basic legal concepts that we have discussed. So if I were you, I wouldn't worry too much about the reader. I would worry about the slides and the documents and legal instruments. So yeah, but if you need it, because I don't know what you have written down, yeah, you need to print it. Sorry for that. Sorry about that, but it's nothing we can do about it. It's a technical issue. Okay. Again, you can have books, notes, and even a dictionary. You can have also a legal dictionary. If you want, but again, it's gonna be super simple in English. And of course, if you have any questions regarding the meaning of a particular word, because of, okay, the exam is gonna be in English, you raise your hand, and the teaching assistant supervising the exam will help you. So another important point that you need to remember is that only correct and relevant substantiations count. So the advice is not for you to overdo it. Don't overdo it. Don't say too much. What we need you is not to write an essay, but to explain why the question is true or false, and take into account the number of arguments that we want you to make. And I will exemplify that when we will be discussing the questions. So how exactly you are going to do it? I don't know if you are familiar with the BOD exam, if you have had already one, if you have taken one already. But this is how it will appear in your screen. That's from last year's exam. So here's the question, right? You will have the choice to choose whether it's true or false. You click on that. You will be able to navigate freely. You can go back and forth in previous questions. And then when you need to substantiate a question, this is how it will appear. So you see here that there are two boxes. One box in which you have to designate whether the answer is true or false, right? And then also you see a bigger box down below it, which allows you to type. And here again, you see in the parentheses in bold one element. That means that you have to give us one argument explaining why the answer is true or false in your view. And that means that you can take maximum 1 point for that answer, except for the 2 points that the true or false question is already awarded. Yes, I have a question. Yes, Guillem, go ahead. No?
Referring to legal instruments,
Yes.
were you referring to the legal instruments mentioned in the slides, or other legal instruments?
Yeah,
maybe in Moodle?
I'll come to that. These are the instruments. It will be the X convention, UNCITRAL model law, Swiss arbitration law, and then the slides, and then the reader. Oh, okay.
Thank you very much.
Yeah. So that's an important thing. Another thing, because last year, when we first introduced this type of exam, many students asked the question about the number of the questions. The questions will be 30, right? But the system recognizes the substantiation as an extra question. So you will be seeing 42 questions, but in reality, it will be 30, because it's 30 plus 10 substantiations plus 2 extra substantiations that you choose, then 42. So in total will be 30. I'm saying that because I don't want to have you worrying about the number of the questions when you see 42, okay? So the one element means one argument, 1 point, okay? Then the other thing is at the end, as I told you, you will have the opportunity to substantiate 2 more of your own choice. This is a prompt that you're gonna face. It says indicate the question you wish to substantiate by specifying its number. A maximum of 1 point can be awarded for your response. Another interesting mistake that students have made in the past is that they just wrote down the number of the question without adding anything. They say, I remember a student wrote that I want to substantiate question 1, full stop. Yeah. So we need you to specify which question and then add the substantiation, obviously, right? Add your explanation. Okay, these are the materials that you will be given access to. Again, as I said, if you want to have your notes with you, you need to print them. So if you have highlight something, you need to print the slides in order to have them with you. Any questions so far before we turn to the questions themselves, to the examples? No? We're good? Yeah, I cannot save your, okay. If you don't interrupt me, I continue, okay? Okay, examples. So one question that we used in the past is the following. The Swiss Federal Tribunal sometimes hears challenges against ICSID awards, but not often. 3 elements. So what you need to do here is to tell us whether it's true or false, and then give us 3 arguments explaining why this is true or why this is false. And since I'm not here to answer the questions, I would need your help. Who wants to take the floor and tell us whether this question is true, whether the statement, is true or false? Don't be shy. It doesn't matter if you make a mistake. The thing is that we're gonna review some things, the main issues, and yes, Lorenzo.
I think it's false because ICSID awards. So the ICSID has its own annulment committee, and ICSID awards can be kind of reviewed only before that committee. And once they've either been unsuccessfully reviewed or if they haven't been reviewed and the limitation period for review has elapsed, the award is binding like a national court judgment in all ICSID signatory states, including Switzerland.
Okay, that's correct. So the answer is indeed false. You told us also why. We need to give 3 points. So what you said is entirely correct. One other thing that I would like you to remember is how you write your answer. I forgot to mention that. It's important to specify the different arguments. You don't need to write them element 1, element 2, element 3, blah, 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 as I did. But it's important to make sure that you make 3 arguments when 3 arguments are requested. I'm not saying that Lorenzo did not. I'm saying that this is what you need to do. So as Lorenzo said, ICSID arbitration is a self-contained regime, and the annulment of awards conducted by the ICSID annulment committee and non-national courts. That's correct. Another point we could make is that national courts, which relates to the other point that I just made, is that they never hear challenges against ICSID awards because ICSID arbitration has no seat. So that's also an important point to make, which relates to the previous point made by Lorenzo. So no seat, self-contained regime, annulment is conducted by the ad hoc annulment committees. There is no involvement of national courts. And the third point, which summarizes these 2, and we just covered it, is that national courts, what's the competence of national courts when it comes to arbitration? The national courts can hear challenges against ad hoc arbitration, commercial or investment, or institutional non-ICSID arbitration, right? So this is the idea. Any question about that? No hands, nobody? Okay. Next question. Arbitrators have an incentive to disregard the law applicable to the merits. Maybe a question is not covered. These are past questions. So maybe you may find, I don't remember which questions I have put, but maybe if there is a question that you don't remember from the class, maybe it's because we haven't covered it. But I think this one is one that we have covered. Anyway, so arbitrators have an incentive to disregard the law applicable to the merits. Who wants to tell us whether this is true or false? That's a bit more tricky, I think it's, yeah. Do I get to pick someone from the list? Maybe. Okay, maybe Alexandra. There are two Alexandras. Alexandra with an iPad, who's joining us from the iPad, with the iPad. No? Come on, there is no reason to be shy. I'm not a professor. I'm your friend here. Who wants to take the floor and tell us whether this is true or false?
I don't know if you just meant me, but I could answer.
Yes, thank you. I meant, yeah, it's fine. Thank you.
Okay. I think this is true because, first of all, arbitration awards are very rarely challenged on the merits, or at least there are specific grounds for annulment, and those relate to other reasons. So arbitrators do not have to fear their award being challenged. And additionally, arbitrators are appointed by the parties, so they have other incentives that might be more predominant than just the law applicable to the merits.
Yeah, that's correct. It's true. Arbitrators have an incentive to disregard the law applicable to the merits. The phrasing "disregard the law applicable to the merits" it's kind of bold, though, in my view. But in any case, what you said is correct and it's true. The reason is, as you said, because there is no annulment that can be justified based on the wrong application of the law. There is no review of the correct or wrong application of the law. The annulment is usually conducted on procedural grounds. So this means that arbitrators are tend to focus more on procedure. So one of the reasons that something that can hurt their reputation is if have their award annulled. But the annulment of an award is not linked to the application of the law, but it's linked to the procedural issues. So what arbitrators are incentivized to focus on procedure more than the application of the law. Of course, this does not mean that arbitrators do not care about applying the law in correct way, but it's not their primary concern, let's say, based on what we have discussed in class. At least this is what you can infer from what we discussed in class. So yeah, that's true. And we covered that. So that's the idea. Okay. Here, for instance, you see two elements. You could have also added. So one thing that I want to mention is that we mentioned two elements. If you say something which is correct and which is not necessarily what we had in mind, you will be still taking the points. For instance, here there are more elements that you could argue, more arguments that you can make. You could say what Alexandra just said. You could also say what I said about the procedural grounds on which annulment can be excused. You could also say that arbitrators that the wrong application of the law is not the ground on which the annulment can be excused, and add to that that if it is egregious, what we discussed in class, for instance, it may also lead to the annulment in exceptional circumstances when the legal mistake amounts to absence of reason. So I'm saying that it's possible that you may have more elements to say from the elements that we require you. You do not need to worry whether you said the element that we had in mind, as long as the element that you are giving us, the argument that you articulate, is relevant and correct. Okay. Next question. Yes, Savoya. Yes, sorry. I don't know if I pronounced your name correctly.
Sorry. I'm just wondering if we have only one element correct on the twos. Will we have 0.5 points or no points at all?
If you have one element correct and we need you to make two, you will take 1 point out of 2.
Okay, thank you.
And if you have, if your answer in the question, if the question is true, the statement is true, and you answer correctly, you will be taking 2 points for that. In addition to that, because there is another thing that I forgot to mention, is that if you got the question wrong, and and based on your substantiation, you tell us we understand that you know the answer. For instance, if you say here arbitrators have an incentive to disregard the law applicable to the merits, and you say this is false, and your argument shows that you meant true, you will be taking all points. Okay.
Okay, thank you.
Yes, the merits of disputes are governed by national arbitration laws, arbitration rules, and soft law. Who wants to tell us whether this is true or false? I don't know. It's fine. Share your thoughts. Maybe Lucy or Maggie? No? Philip? No? Nobody? Okay. Okay, I'll answer the question. The question is, the statement is false. And here we want you to give us 4 arguments. Obviously, the good news is that we're not going to be using the same question again. So don't worry. Then I'll try to show you how to think if this kind of question appears in the exam. You see 4 elements, and you see national arbitration laws, arbitration rules, and soft law. That means, and the merits of disputes. That means that we want you to comment on this. We want you to tell us whether national arbitration laws cover the merits of the dispute, whether arbitration rules cover that, and whether soft law cover that. And the reality is that no, national arbitration laws are procedural. They do not cover the merits of the dispute. The same applies to arbitration rules, and soft law. And then we want you to tell us what covers the merits of the dispute. You see, for instance, element 1, national arbitration laws govern the procedure, law of the seat. Arbitration rules, such as ICC, govern the procedure. National laws govern the merits of the dispute. They are substantive laws. This is also an element that you had to mention. And the 4th one is the following, that we want you to tell us that arbitration is based on party autonomy. The parties are free to choose any law they prefer as applicable to the merits. It could be even a combination of different national laws or transnational rules or lex mercatoria, or soft law rules if they are substantive. So here is a difficult question because it deals with the interplay of different laws in arbitration, which I would like to discuss later on. But the only thing that I want you to point out is that in arbitration there are different laws that apply. There are substantive laws which apply to the merits of the dispute, and there are many procedural laws that govern the procedure of arbitration. This is national arbitration laws, Swiss arbitration law, for instance, which becomes applicable by virtue of the party's designation of the seat. So once the party designates Geneva as their seat of arbitration, and the parties only designate a city, not a country, as a seat, then by doing so, they make Swiss arbitration law applicable. And Swiss arbitration law is procedural law. Is a law that says, for instance, the grounds that sets out the grounds of annulment, for instance. Then we have arbitration rules, institutional arbitration rules. For instance, ICC, Stockholm Chamber of Commerce, LCIA, or the Swiss Arbitration Center. All these private institutional rules apply concurrently with national arbitration laws. They do not exclude, one does not exclude the other. And that's very important to remember. They apply together. And it's very rare. It's almost impossible for these rules to contradict national arbitration laws, because, for instance, when you apply ICC in an ICC arbitration, you apply ICC rules, and usually you also have the arbitration seated in Paris, or even if it's not the case, there is no conflict between them, because they are covering different things in practice. And then you can have national laws, substantive laws, so Swiss contract law, for instance, or I don't know, Greek contract law. And then you can have a combination of the different applicable laws, because arbitration is based on party autonomy. So the parties could say that we're going to have Swiss law, Swiss contract law, and Greek contract law applicable for different parts of the contract, for instance. So there are different laws that apply in arbitration, mostly procedural, and apply together. That's an important thing that we want you to remember. Any question about that? Because that's an important point to remember in general. No, it's clear. So we can have, for instance, an arbitration seated in Switzerland, in Geneva, Switzerland. It will be that is also an ICC arbitration, and the applicable law, the substantive applicable law, could be German law. So here we're going to have three laws applicable, right? We're going to have Swiss arbitration law as the law of the seat. We can have ICC arbitration rules and the German law. In theory, because arbitration is based on party autonomy, you can also have a combination of different procedural rules that apply. Nobody does that because it's crazy, but in theory, I'm mentioning it just for you to understand the extent that this can go to. We can have, in theory, Swiss arbitration law in addition to the Greek arbitration law or Greek procedural law, in addition to ICC rules. It's going to be crazy, but the idea is that there are different procedural rules that may apply in arbitration. Next question. The concept of material jurisdiction does not exist. That is a very easy question, and who wants to tell us why this is false? It's false, yeah. Please, I need someone. Maybe Ben or Daria, Katerina, Gabriel.
Yes,
Yes, thank you.
I can answer. So this is false because arbitration does have material jurisdiction limits. So only disputes that are arbitrable fall within arbitral jurisdiction. Yes, and matters like, for instance, family law or some public law issues are non-arbitrable, showing that ratione materia does exist.
Yeah, that's correct. Thank you. In a sense that the concept of material jurisdiction exists in every dispute settlement mechanism, whether it's commercial or investment arbitration, or whether it's I don't know, court adjudication. I assume you were referring to arbitrability. Arbitrability is also something that concerns material jurisdiction. That's true. Another point we could make, arbitrability, I hope is clear to anyone, that refers to the kind of disputes, to the type of disputes that can be arbitrated, that can be resolved by arbitration. That eventually limits the material jurisdiction of arbitral tribunals. Here also you could have made, if you were asked to substantiate the question, you could have also mentioned or drew a distinction between commercial and investment arbitration. In both settings, the concept of material jurisdiction exists. Arbitrability is one aspect of commercial arbitration. In investment arbitration, we have the concept of of investment in ICSID, for instance, we discussed that, or even outside the ICSID. Then the other thing you could have mentioned is that in the context of commercial arbitration, that we have the competence principle, which suggests that tribunals have the power to assess their own jurisdiction. This, for instance, what I mentioned here, or again, arbitrability. So it's there is another thing, the distinction between ICSID and non-ICSID. I'm just giving answers. It's not doesn't mean that this is what you needed to say. You don't need to follow the exact phrasing. You just need to point out the important concepts. Okay. Another question. Yes, William.
Thank you. So concerning question 7, so you say that had we an arbitration proceeding in Switzerland, we'd have Swiss arbitration law as the law of the seat, ICC arbitration rule, and then you said German law. You said something like Swiss German law or German law.
Yeah, it was an example. I said that the parties can do basically whatever they want, and they can select different laws that apply. Either that different laws that either regulate procedure or substance. So they can combine laws if they want to. It doesn't matter if it was an example. Yeah.
And so in this example, for example, the German law, this would be the applicable substantive law. Oh, okay.
Yes, in theory. So there is a substantive law and procedural law.
Yes.
The substantive law deals with the merits of the case. That could be German law if we want it to be German law. And then we can have an ICC arbitration seated in Switzerland, in Geneva, and the applicable law to the merits of the case can be German law.
Okay.
That's possible in theory. It can be other law. I don't have any preference to German law. I mean, I just wanted to show the example. There is one more thing when it comes to applicable laws in arbitration, which is a law that applies to the validity of the arbitration agreement and the validity of the contract. That's an important thing as well. I have it later on, but I'll mention it now. That's an important thing to remember because this relates to the separability principle. If you remember, the validity of the arbitration agreement is to be separated from the validity of the main contract, of the contract in which it forms part. That means that is not impossible for both, for the contract and the arbitration agreement contained therein, to be invalid at the same time. They can be invalid at the same time, but there is no correlation between the validity of the contract and the validity or invalidity of the arbitration agreement. The fact that the contract may not be valid does not necessarily mean that the arbitration agreement contained in that contract will also be invalid. They may be invalid because the same reason that invalidates the contract can at the same time invalidate the arbitration agreement. One example is that I point a gun at you and I blackmail Guillem and I force his will to sign the contract, which in the contract there is arbitration agreement. So at the same time, I forced his will to do both, to sign both. The separability principle is a legal construct. In reality, we have a document, and the arbitration agreement is an article, a provision within the contract. But in legal terms, we think it as a separate agreement for practical purposes. Because if we do not have separability principle, then anytime someone could say, oh, the contract is invalid, then the tribunal wouldn't be able to deal with the case. It wouldn't be able to determine whether the contract is valid or not. Why? Because it wouldn't have had jurisdiction, because the invalidity of the contract would lead to the invalidity of the arbitration agreement automatically. So this is not the case. It can happen because, again, I force Guillem's will to sign the contract in which there is an arbitration agreement, But the invalidity of the arbitration agreement comes not from the invalidity of the contract, but from the fact that I forced someone to sign the contract. Okay, so the same thing invalidates both at the same time. This also, the separability principle, suggests the fact that we treat the arbitration agreement as a separate contract suggests that there can be a different law that regulates, that governs the validity of the arbitration agreement and the validity of the contract. It can be the same as well, but it can also be different. So to sum up the thing with the different laws that apply to arbitration, we have some procedural rules, the law of the seat, okay, the institutional rules that may apply, they may not apply, but they may apply, depending on whether the parties want them to apply. And we can have also other procedural rules if we want. I said law of the seat, other procedural rules, Greek procedural law, ICC rules, or other institutional rules. We can have a law of the validity of the contract, the substantive law of the merits, and a different law that applies to the validity of the arbitration agreement. I hope this is clear. If not, I can repeat it. So there are many different laws that apply to arbitration. Is that clear? I said too quickly. I have to speak quickly.
Thank you very much.
Okay, good. Okay, next question. As long as states allow it, arbitration, international commercial arbitration would exist. Who wants to tell us whether this is true or false? Maybe who? Let me pick Roxana. Are you here? You have also your camera open. Would you like to tell us why this is true or why this is false? No? Yeah. Left? No, you're here. Okay, yeah, thank you.
I'm thinking, well, on one hand, it's true if we think of the concept of arbitrability, but I'm not sure if I'm going into the right direction. If certain matters are arbitrable, and then, of course, then we can link this to the concept of party autonomy, as long as the parties to the contract agree to submit their future disputes to arbitration, then yes.
Both of them are correct. However, the fact that the parties may not decide to opt for arbitration does not mean that the concept of arbitration does not exist. It does not exist for them. So both of them are correct. That's true. So we need the parties' consent to go to arbitration. But here we will be referring mostly to the concept of international commercial arbitration in general. So your point about on arbitrability was correct. So this is what we had in mind. Now, for instance, let's say that you have these two points in your mind and you cannot decide which one is correct or not, or which one we probably need. What I would suggest you to do is to explain that, to say, for instance, that if you are referring to international commercial arbitration in general, that will require state consent, in a sense that states will need to accept that possibility by passing their laws, arbitration laws that determine arbitrability. So yes, if there is arbitrability and if they have this arbitration law, yes, that arbitration can exist. However, if you could also have said that, explain that if you are referring to arbitration in specific circumstances, or if I'm gonna see that from the lens of the parties, that also requires, apart from an arbitration law, also the parties' consent. So if you are not exactly sure about what you need to cover, explain that in your answer. Of course, even if you did not do that, I believe that if you have given us the second part of your answer, still you will have taken the points. But to be fair, what we were referring here is to international commercial arbitration in general, not to. Another point I need to make is that you need to pay attention to the wording. I'm not saying that you did not. I'm saying in general, you need to pay attention to the wording of the prompt, because it has some hidden hints. Here, not quite, but there are certain words that are not neutral, such as, for instance, always, the word always, or the word definitely, or I don't know, all the time. This kind of words that are not neutral, I think, are hidden hints, because they are giving you the direction that you need to go. Or words such as never, like these bold statements that are very bold. So these are kind of indicators of that something may go wrong in the answer. For instance, if you had the question like investment treaties always increase investment flows, that word always is too general, too bold, and probably indicates that the answer is wrong. The statement is wrong. That's also an important point to think in mind. Yeah, that was also correct. So, any questions so far? Before we turn to the main legal concepts quickly, I will go through them and discuss them. No questions so far. Everything. Now we have two scenarios. Either everything is clear, or I'm terrible and nobody understands anything. What should I consider to be true? Yeah. Okay. So these are the legal concepts that you need to know, and that we have covered in class extensively. I think. I won't be going through them one by one unless you want me to. But I'm gonna say a few things about each of them, okay? I'm not gonna cover them in detail, because this will require more time than in 1.5 lecture. However, if you have any questions, substantive ones, or if you came up with questions during your preparation, you come and find me. I mean, you cannot come and find me. You reach out to me and email me. We can have Zoom sessions if something is unclear, or I can answer questions in writing. Don't be shy if something is unclear. You can email me anytime you want, and I can answer substantive questions anytime you want, except for 1 day before the exam. Okay, I cannot answer questions 1 day before the exam. So you have until the 13th of January to let me know. Okay.
Sorry, could you? Are we going to have a Q&A session at the end of this this meeting, or can we ask questions now?
You can ask questions now. Now it's
all right. Great. Thanks. So I have one question on one of the end of lecture questions that we addressed, I think, in week 5 or 6. And the question was basically, so the statement was, a tribunal cannot render an award determining that the arbitration agreement is invalid.
Okay. Cannot render an award determining that the arbitration agreement is invalid. Yes.
And the answer that the professor gave was false. And I struggle a bit with this one, because it implies obviously that tribunals can render an award determining that the arbitration agreement is invalid. Except if the arbitration agreement is invalid, I don't understand on what jurisdictional basis they can render an award at all. But then obviously at the same time, if the arbitration agreement is invalid, then probably the only thing that they could do following that logic would be to basically kind of informally tell the parties to go away because they can't do anything, right? So what's the solution to that riddle?
Yeah, that will be totally correct if we haven't invented the concept of competence principle. The competence principle suggests that tribunals have the power to determine their own jurisdiction. And they do have the power, because otherwise, as you said, it wouldn't be able for them to render an award declaring the invalidity of their arbitration agreement. So the answer to that question is that indeed this is possible, and the legal base for that is the competence principle, which is something weird for us for someone who is not familiar with international adjudication in general, or arbitration in particular, because in national courts we don't have this concept, right? We have material jurisdiction, in a sense that a civil court, criminal court, administrative court, but we don't have the idea of competence principle. Here we have it because arbitration is an exception to the natural judge, right? Parties do not go to their national courts, and they go to arbitration. And for practical purposes, in order for arbitration to be meaningful, then we have the competence principle. So the competence principle relates to the separability principle in that sense, because separability principle says they complement each other actually. Separability principle says that the validity of the arbitration agreement is not linked to the validity of the contract it contains the arbitration agreement. Although, as I said, no, this is not absolute. And competence principle, the positive effect of competence principle, says that tribunals have the power to determine the validity of the arbitration agreement, to determine whether they do have jurisdiction. So this gives them the power to say whether they do have jurisdiction and to conclude that they don't have jurisdiction. Otherwise, if this did not exist, then the only solution will be for the parties, for the tribunal to refer the case to national court, and the national court will have to determine whether there is a jurisdiction for the tribunal, and if that will be the case, then the court had to refer the parties back to arbitration, and then arbitration to proceed. So that's why we have the positive effect of the competence principle, and what I just mentioned, the negative effect of the arbitration of the competence principle, which says that when a court is seized with a prima facie valid arbitration agreement, an arbitration agreement that appears to be valid, then the court has to send the parties to arbitration, because this is a matter that the arbitration has to, that arbitrators have, the tribunal has to determine in final terms. So the jurisdiction, the issue of jurisdiction, which is an issue that relates to the validity of the arbitration agreement, is in the hands of tribunals because of the positive and negative effect of the arbitration of the competence principle. Otherwise, arbitration will be impractical. At the end, you could consider that the final judgment the final judgment of whether there is indeed jurisdiction is in the hands of national courts, because the award can be annulled if there is no jurisdiction, right? So if the tribunal get it wrong, then the award can be annulled. But this comes at the later stage, again for practical purposes. So the answer to your question is that what you said, it would have been true if we did not have the competence principle, which allows the tribunal, gives a legal basis to tribunals to ascertain their own jurisdiction, namely the validity of the arbitration agreement. Yeah.
Okay, that makes a lot of sense. Thank you very much. Maybe if I would just may as a follow-up question.
Yes.
What is the legal source of the competence principle? Is it in the lex arbitri of basically every single state on earth? And if yes, are there any exceptions to this? Or is there a different source, maybe in customary international law or something like that?
Yeah, that's a good question. I believe it's both. I believe that there are certain national arbitration laws that explicitly mention that. But even if that is not the case, I believe it's also a custom thing. Nobody judged that. It's like yeah, I think also it comes from custom as well. Now, where exactly this comes from, I have to check, and this is not something that students that you need to worry about for the exam. The idea is that it's that you need to remember that it's a legal construct, it's a legal principle, it comes from customer. It has become custom, as a legal principle. Nobody will say otherwise, but you can also find it in national arbitration laws. Now, if there is an exception to that, in theory, national states can do whatever they want when it comes to their legislation. They can decide to pass an arbitration law that is not arbitration friendly, and they could, in theory, say that competence principle does not apply. I haven't seen that. I don't think that this will ever happen. But in theory, you could say that this could happen. Yes, in theory, there have been arguments in legal theory in Greece. For instance, I was in a conference last week and I was debating with someone. We almost argued, fight that. He insisted that Greek courts have to review the substance of arbitral awards, which is something that doesn't happen in arbitration. But he thought he's a professor. He thought that this needs to happen, and that the state has to regulate accordingly, arbitration accordingly. In theory, everything can happen when it comes to regulation. But in reality, I don't think this will happen because it will be contrary to arbitration. It will be something that only a non-arbitration friendly country would pass. So I don't think that there are exceptions to that. Okay.
Okay, very interesting. Thanks, Dimitrios.
No worries. Okay, so if there are other questions, please interrupt me. Let me start with the different types of arbitration. I will go one by one. If you have questions, you stop me, you interrupt me, and then we are done. So different types of arbitration. You need to remember that there are commercial arbitrations, domestic and commercial arbitrations, investment arbitrations, domestic and international arbitration. Obviously, investment arbitrations are always international. Do you know why investment arbitrations are always international? The answer is because foreign it's an arbitration, a dispute settlement mechanism open to foreign investors against states. So there is a foreign element. They are international. And there's another distinction that you need to remember, which is very important: ad hoc and institutional arbitration, either commercial or investment. When it comes to investment, you need to remember that ad hoc and institutional arbitrations are treated procedurally the same, except for exit arbitrations, which is a different creature. As we said before, it's a delocalized, self-contained arbitration, a self-contained regime, delocalized arbitration. There is no seat, there is no involvement in national courts. When I say that in ad hoc and institutional non-exit, namely non-exit investment arbitrations, are treated procedurally the same, I mean that we treat them as if they were commercial arbitrations. Please do not mention in the exam that investment arbitrations are like commercial arbitrations. No, because the main difference is that is the material jurisdiction, is the subject matter of the disputes changes. And of course, the applicable law changes. In investment arbitration, we have international law and treaties. In commercial arbitration, we have national laws, probably. But procedurally, they are treated the same, and this is what you need to remember, because both in commercial arbitrations and both in non-exit arbitrations, we have annulment by national courts, we have seat, we have the New York Convention applicable when it comes to their enforcement. So different types of arbitrations: commercial, investment, ad hoc, institutional, exit, non-exit, international, and domestic. Okay. Competence principle. I'll share that with you, so you can read them afterwards. So we refer to that because Lorenzo, I think, was because of Lorenzo's, I think, question. So the idea is that tribunal is empowered to ascertain its own jurisdiction. I refer to the positive and negative effect. I also we also discussed with Lorenzo the efficiency issue, that this is something that sustains the efficiency of arbitration. So if you come up with a question like, without the competence principle, the efficiency of arbitration will be jeopardized, then one or two elements, then you need to say that is true, and then explain why. And the answer is that because without it, every time a party disputed the validity of the arbitration agreement, namely the jurisdiction of the tribunal, every time one of the parties said the tribunal does not have jurisdiction, then the tribunal will have to refer the parties to national courts, something which makes arbitration practical. Of course, another issue of jurisdiction is arbitrability. We covered that, right? It refers to the type of disputes that can go to arbitration. And of course, what competence practically suggests, apart from the efficiency issue, is that tribunals render an award declaring the validity of the arbitration agreement. That was exactly the question that Lorenzo mentioned. I have covered separability principle. Again, it refers to the fact that there is no link between the validity of the arbitration agreement and the validity of the main contract. Again, this does not mean that it is absolute. Both can be invalid at the same time, because the same reason that invalidates the contract can at the same time invalidate the arbitration agreement. And the significance is that also the tribunal is empowered to render an award declaring the contract invalid, because it has a jurisdiction to do that. If, in the absence of the separability principle, for instance, the invalidity of the contract would automatically lead to the invalidity of the arbitration agreement, which automatically would suggest that there is no jurisdiction. So the tribunal will be prevented from rendering an award declaring that the contract is invalid. So both the separability principle and the competence principle sustain the efficiency of arbitration. The competence principle allows the tribunal to render an award declaring the validity of the arbitration agreement, rejecting jurisdiction. And the separability principle allows the tribunal to declare that the main contract is invalid. These are two important points to remember. Okay? And then, yeah, the limit not absolute. Yeah, we covered that. You don't need to focus on that. Arbitrability. Any questions so far? Sorry, before discussing arbitrability. Is everything clear, or we need to clarify something? No? Okay. Arbitrability. Yeah, so we said that arbitrability has two main meanings. Professor Schultz said in class that the subjective meaning of arbitrability, which is mostly prevailing in the US, is not that important. So what I need you to remember is mostly the objective meaning of arbitrability, which refers to the kind of disputes that are to be submitted to arbitration. The other thing that I need you to remember is that every national legal system has its own rules. That means that whatever is arbitrable in Switzerland is not necessarily arbitrable in France. And why we should care about arbitrability? We should care about arbitrability because it affects the annulment and the enforcement of an award. And why it affects the annulment of an award? Because the law of the seat says so. It is one of the grounds on which the annulment of the award can happen. The award can be annulled. Take, for example, the uncitral model law. The uncitral model law, I would like you to remember, is not a substantive law. It is a procedural law. It's a model law that states can copy or consult when they pass their own national arbitration laws. One ground on which the annulment can be executed is arbitrability. And that makes sense, right? Because arbitrability refers to the type of disputes that can validly resolve in arbitration. If under that law, under the law of the seat, a dispute is not arbitrable, then the award will be annulled, because that legal regime, that legal system does not allow for that kind of disputes to be resolved in arbitration. Then arbitrability also affects the enforcement of an award. Who says that? New York Convention. In Article 5 of the New York Convention, which you will be able to access during the exam, and I forgot to add it, so I need to do that. And also, which you need to know and remember, or have it with you, is Article 5 of the New York Convention. In Article 5 of the New York Convention, one of the grounds on which the enforcement can be rejected is arbitrability. An important thing to remember is that arbitrability is governed by two different laws at different legal stages, right? At the annulment stage, it's covered by the law of the seat. You cannot, an award seated in Geneva, in Switzerland, an award rendered by a tribunal seated in Geneva, Switzerland, can be annulled if it regulates a dispute that is inarbitrable in Switzerland, that is inarbitrable under the Swiss arbitration law, under the law of the seat. An award, if we take that award and we attempt to enforce it, let's say that this award has not been annulled, right? And we attempt to enforce it in Germany, that award, whether that award can be enforced or not, depends, among other reasons, on whether the dispute is arbitrable, not under the Swiss law, not under the law of the seat, but under the law of the enforcement forum, whether the German law, the German arbitration law, allows for the dispute that the award regulates to be arbitrated in Germany. Because this is normal, because we need to focus on the legal system which will embrace, within which the arbitral award will be valid, because enforcement means validity of the award within the legal system, within the enforcement forum, within the legal system where the enforcement takes place. So it makes sense. A quick way to remember that, if you don't want to go through all the fuss, is that every national court applies its own law. So when we have annulment before the national courts of the seat, they will apply their own law. When we have enforcement before the national courts of the enforcement forum, they will apply their own law, right? Regarding the enforcement, I would like also to point out quickly that there are two articles that you need to remember when it comes to the New York Convention: Article 2 and Article 5. Article 2 refers to the negative aspect of the competence principle. It says that whenever a court is seized with a claim with a dispute for which there is an arbitration clause, which appears to be valid, prima facie valid, then the court has to refer the parties to arbitration. Article 2 of the New York Convention. And you also need to remember Article 5 of the New York Convention, the grounds on which the enforcement may be rejected. Another point that you need to remember when it comes to the New York Convention is basically that it has permissive language, in a sense that whenever there are reasons under which the non-enforcement, the rejection of enforcement of an award can be excused, then the court may decide to non-enforce the award or otherwise, in a sense that there is no mandatory non-enforcement. The New York Convention is arbitration friendly, and it allows the enforcement of an award even if the grounds that excuse the non-enforcement are met. So even if in theory, this could happen. Even if there is an inarbitrable dispute, then the award can be enforced if the state courts decide so. It's not mandatory for state courts to reject enforcement, even if this could have been excused under the New York Convention. Whatever I said about arbitrability, and the different laws that applies also to public policy grounds, right? But you don't need to know more about that. Any questions about that? Any issues? Any clarification that you may need, or should I move on? Because I don't want to keep you too long. Okay, seat of arbitration. That should be crystal clear. We have already covered that. You need to remember the legal significance, the legal repercussions, consequences of the designation of the seat. When the parts choose the seat of their arbitration to be Geneva, that means that the Swiss arbitration law will apply. That means that the award will be considered Swiss for the purpose of the enforcement. That means that it will allow the intervention of the JASWE and national court in support of arbitration that helps with challenges of arbitrators mostly. This exists, I think, in Switzerland and also in France and possibly in other legal jurisdictions. This also determines the annulment, the grounds on annulment, and of course the annulment courts, and also affects the enforcement, may affect the enforcement. And I say may because the annulment of an award may lead to the non-enforcement of that award, because if you check Article 5 of the New York Convention, again, it is said it is one of the grounds on which the enforcement may be rejected. If an award is annulled by the courts of the seat, then you cannot enforce that award. There is an exception to that, again, because there is the permissive language of the New York Convention, especially in France, where courts tend to enforce annulled awards, whereas the prevailing view is that an annulled award is an award that does not legally exist. So you cannot enforce something that does not legally exist. You don't need to know more about the enforcement of an annulled award. However, if you want to know more, I have published a blog post a few years back that you can check it out on Kluwer Arbitration blog. But the important thing that you need to remember is that the annulment of an award is a ground on which enforcement can be non-enforcement can be excused. Here are the applicable laws of in arbitration. We have discussed that already, so I believe you don't have any questions. Yeah, it's a bit complicated. Again, it's procedural rules, substantive rules. You need not to remember the overriding mandatory rules. We haven't covered that in class this year. So there is a procedural rules, the law of the seat, institutional arbitration rules, or other procedural rules chosen by the parties. There is the law governing the arbitration agreement, which, as I said, can be the same or a different law than the law that governs the validity of the contract. There is a substantive law, the law applicable to the contract, and there is also the law governing the arbitrability of the dispute. As I said, in different law at different stages. The law of the seat applies at the enforcement at the annulment stage. The law of the enforcement form applies at the enforcement stage. The overriding mandatory rules mentioned here, you don't need to remember them. And the law governing legal capacity, again, it's obvious. It refers to the law that governs the capacity of the parties to designate to conclude a contract. Again, you don't need to remember that, but I think you are already familiar with this kind of law, with the concept of legal capacity to enter into a contract. Procedural rules, substantive rules, okay? Enforcement annulment, I think we have covered that. Again, the distinction here is crucial: commercial arbitration and mixed investment arbitration. The courts of the seat apply to commercial and non-mixed arbitration, mixed annulment committees. The same applies to enforcement. The enforcement of non-mixed awards or commercial arbitration awards is based on the New York Convention. The enforcement of fixed awards based on the ICSID Convention. And what I said in my session was that you can use the New York Convention to enforce and X the award in a non-X country, it's possible under certain circumstances. You can you don't need to know more than that, but except for the fact that it's possible to use a New York Convention to enforce a non-X award an X award in the non-X country. And the last thing I want to go through quickly is the yes, I have a question. Yes, William. Hello? Yeah, you can take the floor. No, okay. Okay. Anyway, yeah. Interrupt me if your question, if you have a question. So arbitration without privity. This is what we discussed in the context of investment arbitration, where we said that there is we cite. Yes, go ahead.
Oh, excuse me, I had a problem with my mic. Can you hear me?
Yeah, yes, I can hear you. Yeah.
Okay, so my question was as to the question mark next to the New York Convention in the last slide.
Yes, I'm going there.
So, as to exceed investment arbitration, for the enforcement of exceed investment arbitration, does the NYC we apply the NYC Convention?
Sorry, it's my computer.
Oh, no
Hello?
problem.
Yeah. Let's try again. Oh, give me a sec because there's a battery issue.
Sorry for making you wait, everyone. My question.
Hello, I'm back. Sorry for that. Yeah, technology. Okay, so
It's my fault. It's my fault. My bad.
no, it's my part. Yeah, go ahead.
Well, my question was as to the exit investment arbitration. Can we apply the New York Convention to exit investment arbitrations? Because there's a question mark next to the convention, the slide.
Mm-hmm. Yeah, we can apply the with the New York Convention only to enforce an exit award in a country that is not an exit contracting state, because there is no other way to do that, to enforce an exit award in a non-exit country, only if you use a New York Convention. However, in order to do that, since we are discussing, we need to and there is a legal requirement that basically that the commercial reservation does not exist. If you go and see the New York Convention in Article 2, I believe, or 1, I think it's either 1 or 2, you have to check. It says that it allows states, contracting states to the New York Convention, to apply the New York Convention only to disputes that are commercial. So if that state has, if the contracting party of the New York Convention has used the commercial reservation, has opted for the commercial reservation, then you cannot use the New York Convention to enforce an exit award in a non-exit country, because that state has accepted the New York Convention under the reservation to be applicable only in commercial disputes. We haven't covered that in class though, so that's why I told you that you only need to remember that it's possible to use the New York Convention to apply to enforce a non-exit award. And let me now turn to the very last part, which is the arbitration without privity. Let me see if I can share my screen again. And sorry again for the yeah. So so I believe you can see my screen now, right? Again, okay. Yeah, we said that. Okay, arbitration without privity. So basically, we covered arbitration without privity when we refer to investment arbitration, and mainly the consent to invest, the state consent to investment arbitration. In investment arbitration, we move away from the traditional paradigm, the traditional understanding of arbitration. In commercial arbitration, we knew that arbitration is contractual based, right? We need a contract between two parties. In that contract, there is an arbitration clause. Remember the separability principle that we discussed. And then when something goes wrong, one of the parties can sue the other party before arbitration, utilizing the arbitration agreement in the contract. This can happen also in investment arbitration, we discussed, because we can have a contract between an investor and a host state. These contracts are called investment contracts. But this is not always the case. We can have investment arbitration even without a contract, even without a contractual relationship between the investor and the host state. And this is called arbitration without privity, because states give their consent to investment arbitration through investment contracts, and through investment treaties and their investment laws. In these two instances, when we have an investment treaty or when we have an investment law, there is no involvement of an investor. There's no contractual relationship between the investor. Instead, and between the investor and the host state. Instead, the host state gives an open-ended offer to arbitrate to an undefined number of investors who can later on, by filing their claim, accept that offer. And this is called arbitration without privity, exactly because the investor is not privy to investment treaties or privy to investment laws. There is no involvement of the investor in both. This has two consequences. As I said, it's an offer to an undefined number of investors. And most importantly, it means that states cannot commence investment arbitration against foreign investors when we are in an arbitration without privity setting, because there is an offer to arbitrate, which the investor accepts, but that offer is not an offer that is not an offer that allows the state to sue the investor. It's an offer that allows the state to be sued by the investor, that allows the investor to sue the state. So it's debatable whether in an arbitration without privity context, the states can sue investors in investment treaties. It's not debatable in an investment contract, of course, although it rarely happens. Okay, so that's an important concept coined by Jan Paulsen, which indicates that we have a paradigm change in arbitration, in international dispute settlement in general. We don't need to have a contractual relationship between these two. That's also new, even if you consider interstate disputes, right? Because even in interstate disputes, we have a kind of contract between states, which is a treaty, right? But here we have a third party, a party which is not privy to a treaty, being able to use a treaty to sue a state, but without being in a contractual relationship with that state. And that's an important deviation from the norm, I would say. Then we covered the notion of investment. We said that there is no definition of investment in the ICSID Convention. And we referred to the three approaches: the objective, the subjective, and the double barrel test. Here are the Salini criteria, and then the focus on the subjective approach focus on the definition of investment in the relevant investment treaty. I see a comment in the chat. I cannot open it, so please take the floor and let me know what's going on. Okay. And then we referred to the double barrel test, which is a combination of these two. And we said that ICSID tribunals have to satisfy themselves that there is an investment both under the objective and the subjective approach. In non-ICSID arbitrations, we said that there is no such a need. There is no necessary application of the double barrel test because there is no application of the ICSID Convention. The Article 25 does not necessarily apply. So we focus on the subjective approach. We also said that tribunals have also used the double barrel test even outside the ICSID context. One example that I mentioned is the Romac versus Uzbekistan tribunal. And then, of course, in ICSID arbitrations, Article 25 applies, so we have the double barrel test. So, any questions? Because that was the last point that I had to make today. Any questions? Anything that is not clear, or anything that you want me to repeat and clarify? No? Okay. In case something is unclear, or in case you have any questions, write to me, and I can either reply via email, or if it's something more time consuming, I can also have it a Zoom one by one with you. I have done it in the past as well. Thank you very much for being here. I'm sorry for the technical issue that I faced. And I enjoyed the semester. I hope you enjoyed that as well. And I hope I'll see you next week, where I will be presenting my PhD to you. Lucky for you, good for you. You're lucky. It's not mandatory to attend, and it's not gonna be part of the exam. Also, what we discussed yesterday is not gonna be part of the exam. focus on the on what we said in class, on the PowerPoint slides, and on what we discussed today. You need to know the basic concepts that we have covered in class, and you will be fine with that. Okay.
Thank you,
Nice.
Dimitrios. Can I quickly ask
Yes.
how many points do we need to pass the exam?
Yeah, that was a question. Yeah, so that depends on the number of points in total. So I cannot answer right now that because we haven't created the exam for January yet. But I can give you, I can check the points for the exam that the exchange students will take. Do I have an exchange student here? No, right? Is there an exchange student? No? Okay.
Yes.
Yes. Okay. Have you sent me your student ID?
Yes, normally, yes, I have sent it.
Okay, great. So for exchange students, for instance, which is the exam is ready, the maximum grade will amount to 78 points. So to pass, you need 4. I think with 35, 40, you will be able to pass. I believe like 72, yeah, something like that. Okay, like 40 points. But I don't think that you need to worry about passing the exam in general. If you focus on what we discussed today, you won't have any issue to pass. You will be heading towards a better grade, a very good grade, I think. Okay. Any other question? That's indicative of what you might need, how many points you might need, but it depends on the elements. You know, for sure, it will be 30 questions multiplied by 2 points per question. That makes 60. So for sure, you need to have 40 points. Then it depends on how many substantiations we ask you to do, how many points, which I don't know yet. Okay. Cool. Yes.
My question would be, would it be possible to have access to the slides, today's slides on Moodle?
I'll upload them on Moodle, but you won't be able to have them during the exam because they don't.
Oh, no problem. Okay, just as a matter of revision.
Yeah, I'll upload them along with the.
Okay.
Okay. Cool.
Thank you very much.
No worries. Thank you, guys, and I'll see you hopefully next week and then in January. Okay. Have a great day and happy holidays. Okay. If I don't see you.
Thank you for everything.
Bye bye.
Have a good rest of your day.
Thank
Bye-bye.
you.
Bye.